That was Marianne Watson, a neighbor of the victim, one of the last people to see her alive. Is that strong evidence? What do we have right now? Let's bring it down with our law and crime trial analyst, Jonna Spilbor. Jonna, good morning to you, even though I'm a little insulted that you're not on set with me.
Oh, don't be. I'll be on set with you next week. Good morning, Jesse.
Good morning, Jonna. Okay, here's my question to you. I've been reviewing the case. I've been following the case. We've all been following the case. What does the prosecution really have against this man? You tell me, what's their strongest piece of evidence to connect him to the death of Jennifer Ann Lewis?
This is a tough case. I wouldn't want to be the prosecutors in this case, Jesse. For starters, it's a 30-year-old case. He's already been convicted twice, but it's highly likely the jury's not going to hear about that. This is the epitome of a circumstantial case. I don't believe they even have any DNA evidence or forensic evidence that actually links this defendant to this crime. They have eyewitnesses. They have that. They can put him in the proximity of this young girl. But beyond that, they don't have a whole lot. It's not an easy case.
Okay, you talked about proximity. So we know that he was with her on the night. We know that he was friends with people that she was living with at the time, and we know that he was in the area. Is that enough? Is that really enough to convict him when we know that there were other people at Jennifer's house that night as well?
Right. So here's the interesting question. It was enough to convict him 2 other times. And the reason his conviction was overturned was because there were problems with either the Brady material that the prosecution didn't turn over or prior bad act evidence that the prosecution allowed in. They got 2 convictions. So if you're the prosecution in this case, you have to say to yourself, we had enough to get beyond a reasonable doubt with not a whole lot of scientific evidence to sew this case together. They're taking a 3rd shot at it, but now they've got 30 years in between. I don't know if it's going to be enough. It's going to be a really tough call.
Johnny, you mentioned the 30 years, and that's what brings me right now to a next clip I want to show, because it has been 30 years since this crime occurred. And a lot of the witnesses are unavailable to testify in this 3rd trial. And that concludes the testimony of Diane Pemberton, another neighbor of the victim. Her transcript that she gave earlier on is going to be read in court. That is what you're about to see. And I want you to listen carefully to the last moments that she saw Jennifer alive. Take a look. All right, so that is the transcript testimony of Diane Pemberton, a neighbor of the victim, being read. And that's a pretty big point for the prosecution. We'll talk about it in a second. Do want to let you guys know out there that our feed in that courtroom is going to be delayed. They're having a late start. We believe that the trial will start today at around 11 a.m. Eastern Standard Time. Again, we will be live in the Liggins case, but it is going to be a little bit later. They're having a late start. As soon as we are live, though, we'll make sure to go there. Want to bring back in Jonna Spilbor to talk about this. Now, Jonna, this is something the prosecution definitely wants to hit on, right? He was driving a very similar car that keeps being described as a car that was pulled next to the victim. And we also know that he was with the victim that night. And we also know, I think that he asked her to buy him a piece of gum at one point. Why that matters, I'm not really sure. But you tell me, isn't this kind of something the prosecution wants to hit on?
It's really one of the only things the prosecution does have to hit on, Jesse. What they have to request of this jury is to make an inference. In other words, to connect dots. Even if the dots might be remote, there's not a whole lot of scientific evidence to connect them. Because here's what they're going to try to get the jury to believe. You know that you have a girl who was brutally murdered, her body burned. That's a fact. We have that science. And the last person to be seen with her alive is this defendant. People are placing her in or near his car. Other witnesses have placed her with him at the store where this gum was being bought. And the next thing you know, this young 9-year-old girl is dead. The dots the jury needs to connect without a whole lot of scientific glue to hold it together is, well, then the last person that was with this young girl when she was alive must be the reason this young girl is now dead. Those are the 2 dots the jury needs to connect here.
This case is so eerie, especially when we show those old crime scene photos, because it did happen back in 1990. I mean, look how creepy and eerie this is, trying to understand what happened to this young girl almost 30 years later. And we'll talk about how that trial, that distance in time affects this trial. But we have to take a quick break, and when we come back, there is so much more to discuss. Stay tuned. All right, so if you're the Liggins defense team, that's not a witness that you wanted to hear. I'm here again with Jonna Spilbor. Jonna, that's not a good witness for the prosecution right there. I mean, this guy is establishing a very important timeline. The defendant was with the victim right before she disappeared.
Yeah, but hold the phone, Jesse, because you got to remember this witness isn't testifying about what he saw yesterday. This witness is testifying about what he saw almost 30 years ago. His recollection is going to be subject to a credibility issue, a reliability issue that the defense can attack. Plus, you got to remember, just because you can put person A with person B at a store doesn't necessarily mean that person A is the one who committed.
Did he seem like his memory, though, was a little off?
Well, I mean, you got to remember, his memory is going to be what he remembers from reading the reports of what he said 30 years ago, because you know that happened in preparation for this trial.
Okay, well, let's stand by, Jonna. We have so much to talk about. That was only a couple of witnesses. I want to move on now to Nathaniel Roden. This is a family friend of Jennifer Ann Lewis, one of another people who last people to see her alive. And this is what's so eerie. I don't care if this happened back in 1990 or today. When you're listening to people talk about the last time they ever saw somebody alive, it's pretty incredible. Let's go to that testimony right now. That was Nathaniel Roden, another important witness for the prosecution. Jonna, do you believe in coincidence? Because this is what the prosecution, I think, is really trying to play out here, and correct me if I'm wrong. Not only did this guy identify that the defendant drives a red car, which is what we keep hearing is the car that we pulled up next to Jennifer Lewis, but also he didn't show up to meet this man right after Jennifer went missing. Coincidence or suspicious?
It could be both, right? If you're the defense attorney, you want to say that it was, simply a coincidence. Do you know what I was thinking, Jesse? I don't know if you recall this case. Do you recall the David Westerfield case by any chance?
I don't, not off the top of my head.
12 or 15-year-old case out in California. Similar, except it's more modern. Family friend was accused of killing the daughter of one of his neighbors. The neighbors were swingers, and they used to have people at their house all the time. Before they even found a body, the police arrested David Westerfield. There was some sort of some suspicion that made them arrest this man. Shortly thereafter, they find, unfortunately, the dead body of Danielle Van Dam, I think, in a dump. But I think you have to credit police officers because they have a sense. And in this case, even though it's almost 30 years old, they must have had a sense when the jury probably will want more than that sense in order to convict. I do not see this case being a slam dunk at all, especially now.
I will agree that I think this is a radically different case than the other two that were tried earlier back in the day. And we're going to talk more about why that may be. And this is a unique case that we've covered here on Law and Crime. So there's so much more to cover. We'll be right back. Stay tuned. Really important witness. Now I want to break it down with Jonna Spilbor. Jonna, this witness talked about a lot of things. Said that the defendant was at the same party, having the same good time as everybody else at Jennifer's house. But he was also questioned about other people being at the house, and he wasn't sure about it. And then he was not so forthcoming, or maybe he just didn't think of it. He said, when you talked to police, did you tell them about seeing two black men there? And he might have, but he wasn't sure. So in my opinion, I think the defense did a really good job with this witness of saying, hey, there were a lot of other people who had a lot of other opportunities to do something to Jennifer. But I'm curious about what your take is.
I think that is going to be the most crucial piece of evidence from the defense camp in this case. Because, look, if you're trying to pinpoint this particular defendant among a sea of other potential defendants, everybody that was in proximity of this young girl essentially could have been a suspect, right? So if you're trying to create reasonable doubt, all you have to do is present to the jury and say, look, there were, let's pick a number, 8 other people that were in her proximity on that same day. Some of the witnesses can't remember what kind of car they saw. Some of the witnesses can't remember who exactly was there. How can you, ladies and gentlemen of the jury, point your finger at my client and say it was definitively him beyond a reasonable doubt? I dare say you can't. And that's the argument that the defense is going to make with this type of testimony.
Well, when we get back, I want to ask Jonna a lot more about the defense's strategy and whether they'll even call the defendant to the stand and what other things will they try to exploit, because we're still talking about the prosecution's case. And when we come back, we got to talk about the lead investigator, Don Schaefer. We'll be right back. All right, that garbage bag becomes a crucial point, and we're going to talk about it in a little bit, so keep that in your mind. But we have so much to talk about with the Stanley Liggins case. Let's bring back on Jonna Spilbor. Jonna, I can't help but think about the gruesome way this young girl was killed. I mean, we're talking about a girl that was sexually assaulted, strangled, burned. I mean, this is a really, really horrible crime. And unfortunately, I know you have a lot of experiences with these horrible kinds of crimes. What does that tell you about her attacker?
Well, first of all, her attacker has to be a coward, because 9-year-old girls just don't have the ability to fight back, especially if we're assuming her attacker is a man. You just don't have the strength to take on an adult. Let's put it that way. Second of all, obviously this person went through great lengths to cover up this crime. I am certainly hoping that much of what the desecration of her body happened after she was already deceased. At least that's what I hope and pray for. This young girl wasn't tortured while she was alive, but we don't really know that. But obviously you have to be a coward when you harm any child, because children simply are defenseless.
Now, when you look at the defendant 30 years later in the courtroom today, I don't know if we can show a picture of him. He looks very different than back he did in 1990. He's an older man. He's got glaucoma. He's wearing these glasses. Does the jury look at it and say, hey, wait a second, this guy, how could this guy have committed this crime?
You know, it's funny because the jury is in the present and the defendant is in the present. And even though the facts and the details that they're getting fed happened a long time ago, you can't help it. When you're sitting in that jury box, you are eyeballing the defendant. You're eyeballing the defense attorney, the prosecution. And yes, Jesse, to a certain extent, they are probably doing those calculations in their head. If you have a defendant that looks like a sweet little old man or a sweet little old lady, that's something that I think they can't help but put through their filter as a juror.
That's what's an interesting point. The 30-year span can hurt both the defense and the prosecution, so it's definitely something to watch. We have to take a quick break, and we'll talk more about that that garbage bag in a minute. But before we go to our break, here's a short message from our very own Aaron Keller. Take a look. All right, we got to talk about this now with Jonna Spilbor. Jonna, you got a silver substance on the body. They think it's a garbage bag, excuse me. They find the same kind of garbage bag in the defendant's apartment. Now, again, could everybody have this kind of garbage bag? Or is it really, 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 really strange that the defendant has the same kind of garbage bag here?
I'm going to play devil's advocate, Jesse. I think the defense attorney could simply say, look, everybody in that jury box has garbage bags under their kitchen sink. Maybe they're silver, maybe they're white, maybe they're black. It's not such an unusual item that to be in possession of it gives one an aha moment that he must be the person responsible for putting her body in a garbage bag that he may or may not have put it in. I mean, it's a gray substance. They're trying to connect that dot. I don't see it as a Perry Mason moment here.
Okay, so we've talked so much about what the defense is going to do with these cross-examination of these witnesses. What do you think they need to do when they ultimately get the case after the prosecution rests?
Oh, well, I have a question. I'm debating whether or not 30 years later this defendant should actually testify. And the reason why I'm debating that is because the evidence is so remote. Because there's a lot, I mean, right now there's some reasonable doubt. If the defendant, if he takes a stand in this case and says, I didn't do it, is that enough? Does that put the jury over the edge if they're already leaning toward reasonable doubt? I'm very curious to see if that's going to happen here.
Well, I'm curious to see it too, and will it happen? I don't know. I don't even know if it's necessary for him to take the stand, but we will talk more about that in a minute and what the defense will do, but we're still talking about the prosecution's case. And the next witness that we have to turn to is Brenda Adams. This is the defendant's ex-girlfriend. I don't think there's much more I need to say. Take a look. That's Brenda Adams, the defendant's ex-girlfriend, talking about that gas can, and maybe it's being used in connection with the Jennifer Ann crime, the Jennifer Ann Lewis crime. We'll talk about that in a second. I want to let all of our viewers know, though, we're keeping a very careful eye on that courtroom feed. We know trial has been delayed today. They're running a little late, but as soon as they're live, we are going to go live. Let's bring back in Jonna Spilbor to talk about this. The weird thing about burning cases, and correct me if I'm wrong, Jonna, is the availability to do it, the means to do it. You know, if we talk about it the same way, if someone was stabbed, there's multiple ways you could do that. But to burn somebody, you got to have a gas can. You have to have some sort of lighter fluid. And here, is it unusual that this man had this gas can available to him, or is that, again, something that a lot of people might have had? And we know that this accelerant was used, and it seemed to be gasoline. So it does seem to be pointing against him here.
I think it's clear that the prosecution strategy in this case is death by 1,000 cuts, right? Because it's not unusual, Jesse, to have a gas can. It's not unusual to have a garbage bag. It's not unusual to have a lot of things. It's not unusual that a person is seen in the vicinity of another person. What the prosecution is going for here is if you have enough of these circumstances in this circumstantial evidence case, that the juror is going to get to beyond a reasonable doubt. But again, a gas can is not a smoking gun. It's just one other dot being connected in this case by the prosecution.
Then what do you think it was in those two previous cases? Because he was convicted 2 previous times by 2 separate juries. Why did they think this man was guilty? Or is it just a situation where, hey, this case this trial, this third one, is a lot different than those first 2. So if that's the case, what makes those 2 trials so different from this one?
Let's keep in mind, back in the 90s, we weren't so, CSI. We weren't so intent or needing to have, like, scientific evidence in order to get a prosecution, number one. Number two...
So wait, you're saying that juries have become more sophisticated?
Well, I think because science has become more sophisticated, so we almost, hey, if there's no DNA, then he didn't do it kind of scenario can be running through their heads today, whereas that wasn't running through any juror's head 30 years ago. Plus, remember, in one of those trials, they brought in evidence that was detrimental to the defendant, prior bad act evidence that apparently was a no-no, so that colored what the jury was thinking about this particular defendant. And then there was a whole bunch of Brady material in another trial that, the prosecution forgot to turn over to the defendant, and that is a huge no-no. So those things, now that that's not happening, and we're 30 years later without a lot of scientific evidence, this jury could go either way.
Okay, but for the people who are saying that he did do this, the argument could be, all right, if someone else did this, what evidence is there? There's been no other suspects, right? In 30 years, they couldn't find the killer. They couldn't find who else did this. Why do they keep going back to the defendant? There has to be a reason.
Well, first of all, the jury shouldn't be relying on that. And I think what's happening logistically is that they will know that there were 2 other trials, but they're not going to know that there were 2 other convictions.
Right.
And that's a big thing. And again, for the defense camp, they could point the finger at every person that was in this victim's house and say, hey, the police could have equally looked at them, but they honed in on my client prematurely, ladies and gentlemen, and for that, you have to find reasonable doubt.
This is a fascinating case to watch, and a lot of angles and a lot of discussion. We have to take a quick break on our end, but when we come back, we're going to talk about Captain David Parrick from the fire department. Take a look. Welcome back, everybody. Before we talk more about the Stanley Liggins case, I want to talk about another case that we are hopefully going to be covering a little bit later on today and that we will be live in. It is in Michigan. I talked about it at the top of the hour. It is the Brad Fields case. This man who is charged with felony murder, second-degree murder, child abuse, and torture in connection with the death of a 4-year-old girl named Gabby Barrett. It is believed that him, as well as the young girl's mother, Candace Diaz, engaged in a repeated pattern of physically abusing this young girl. It is a horrifying case, and we are going to cover it here on Law and Crime. We have to. It is so important. We have to serve justice to this young girl by covering it. I want to bring back in Jonna Spilbor to talk about it. Now, Jonna, this is a really horrific case. The details are really tough to hear, including the fact that we believe this young girl was scalded with hot water at times. I mean, it's really disturbing. For the defense, though, what do they do here? Because in the sense that, I know this case hasn't started yet, but if you have a young girl who's in their custody, how do they excuse the way that she died?
It's hard to keep a dry eye just thinking about what this poor young girl had to endure. But in terms of a defense, you have two defendants here, but they're not being tried together. And I'm wondering if the strategy is going to be each defendant pointing their fingers at the other, which, if in the case of Mr. Fields, who's going to be starting next week, he could be pointing his finger squarely at this young girl's mother and say, wait a minute, I had nothing to do with this. And oh, by the way, Jesse, part of the theory of this case is that the reason this young 4-year-old girl was tortured and ultimately killed was because she wet the bed. That's just horrific. So maybe he's going to point the finger at the mother. Maybe the mother's going to testify against him. We're going to have to wait and see. I'm not sure.
I wonder if the advantage is in her court being the mother, and she could say something along the lines of, well, she was my daughter. How could I ever do this to my daughter? And I was in a position where I was afraid of Mr. Fields and couldn't defend my daughter. Again, we're just speculating here, but what we do know is this young girl was killed, and she was killed in a horrific fashion. I believe that she was unresponsive on the bathroom floor when the police arrived, and her mother told police that she found her daughter submerged in the bathtub after she went to go make her pancakes. We will learn a lot more details of that case once we're live. But speaking of live, we are live right now back in Liggins. We have a live feed in the courtroom. Nothing is happening just yet. As soon as trial starts, we'll make sure to go in there. But that is a live feed right there. So in the meantime, let's recap where we were, where we last left off with some important testimony. I want to just confirm if we have any audio in the courtroom. Is there anything going on? Okay, nothing really that good going on, just a lot of pretrial stuff. As soon as the first witness is called, we'll make sure to go there. In the meantime, I want to play the testimony of Captain David Parrott from the Davenport Fire Department. Remember, Jennifer Ann Lewis, this young 9-year-old girl, after she was killed, her body was set on fire. Let's learn a little bit more of the details of that. Wow. Can you imagine responding to a fire and really what the fire is of a burnt body? Really, really terrible stuff. Back here with Jonna. Jonna, we're talking about this case, and we're talking about the details of how this all unfolded. But we talk about a case that's 30 years old and how we got here. Do you think it's bizarre in one sense that the prosecution is really to blame here? I mean, wasn't it their fault that we now have this third trial?
So, you know what? That raises something interesting, Jesse, that I wanted to talk to you about. Because at this stage, right, third trial, almost 30 years later, as a practical matter, I'm wondering why the prosecution didn't strike some sort of deal. Instead of costing the taxpayer money, instead of using the resources to do this for a third time. The man has been in custody for basically this entire time. I'm curious as to why the prosecution didn't say, all right, listen, you plead to manslaughter, you're going to do another 5 years, and then you're home free. Or maybe they did and it was rejected. That's the kind of things behind the scenes that we don't really that we're not privy to.
Well, couldn't the answer be what's the justice then for the Jennifer's family, in the sense that, hey, listen, the guy gets 5 more years, that's how we settle this? No, it's either all or nothing. And then for him, he could say, I want justice. I've spent so many years in prison. I deserve to have my chance of saying I didn't do this.
Right. And what justice will there be for this young victim if he's acquitted? He could get acquitted and walk out the door at the end of this trial. So it's really hard. And when you have cases that are this old, it is especially hard. But both sides do deserve justice, the victim and the defendant.
There's no denying this is a bizarre and unique case. Have you seen circumstances where if he is acquitted and he can claim I was wrongfully charged, I was wrongfully prosecuted, wrongfully kept in prison for all these years, can he file some sort of lawsuit against the state here?
He sure can, and that's another reason why the prosecution probably should have struck a deal that would include you don't get to sue us, not the prosecution. You don't get to sue the state for the time that you had to spend in prison, and maybe that was the deal breaker. Who knows? But if he were wrongfully convicted and he spent all that time in prison, I'm sure the state is looking at a lawsuit.
Maybe we might be jumping ahead of ourselves a little bit. We got to still have this conclusion of this case, and we can't forget the fact, Jonna, this guy has been convicted 2 other times. Will it be the same time a third time around? Then again, it's been 30 years. It's been a very long time since his other 2 trials, and this trial is a lot different than his other 2. And the defense, you could say, is doing a pretty good job because the prosecution's witnesses and the evidence they put forward maybe it's not as strong as they would have liked. But guess what, ladies and gentlemen? We are continuing on with the Liggins case because we are live. A new witness is on the stand. So you know what we're going to do? We're going live. All right, let's talk a little bit more about this witness right now with Jonna Spilbor. Jonna, not the most interesting of testimony. I'll be the first to admit it. We're learning about the properties of gasoline. But I mentioned at the top, if a prosecutor, if the state doesn't prove every aspect of this case, what could happen?
Well, obviously, you could get an acquittal or perhaps a hung jury, which would lead to the prospect of trial number 4. But I have 2 questions, Jesse, because this testimony is a little confusing. And first, I'm not quite sure why this expert, who obviously was called in a previous trial and is now deceased, which is why the expert's not testifying again. What is the prosecution trying to prove, that there was enough gasoline left in this gas can to pour over a body and set it on fire? That's my first question. My second question is, why read this testimony as opposed to hiring a brand new expert? Experts are not like witnesses who saw this defendant near the victim in the car or saw the defendant. You can't replace those witnesses. But you can hire an expert, and most of the time you can hire an expert to say what you need the expert to say. So to do it in this dry fashion in front of this jury has me scratching my head a little bit.
Yeah, and we've consistently talked about the fact that something's lost when you read the transcripts of these witnesses as opposed to having an actual witness in courtroom. You lose a jury. You might be able to lose a jury there. We have a lot more to talk about, but we have to take a quick break. And when we come back, we'll be live in Liggins, and we have a lot to analyze. Stay tuned. Okay, let's break down what's happening right now in the Liggins case, a really important and bizarre case that we're covering here on Law and Crime. I'm here again with Jonna Spilbor. Jonna, we've seen today how they're trying to outline the aspects of the gasoline, how this young girl was burned. Thankfully, she was not burned alive, but her body was burned, a key aspect in this case. But we talked about what the defense is going to do. We see so much about the prosecution. What kind of witnesses do you think the defense is going to call when it's their turn?
You know, it's quite possible, Jesse, that if the defense feels the prosecution has failed to meet its burden, it's possible they won't put on any witnesses. Or perhaps they have other witnesses that were maybe not spoken to at the time of the actual offense, although that might be a little tricky, to say that there were so many other people at this particular location, or that maybe somebody else saw this young victim with somebody who wasn't questioned by the police. I mean, that's a little bit up in the air. But remember, it's all about the burden.
Do you think there's any value to the fact that his car, the inside of his car, smelled like gasoline after all this interaction, and also that he had this gas can, and that people said he was acting suspicious and that he was near the victim at the time? I mean, adding all this up, you could see how the prosecution could build a case.
You know, a very circumstantial case. But like, for example, right now they are losing the jury with this gas can testimony because it's as compelling as watching gas evaporate potentially. But I don't think, unless they can prove that the gas that was in that particular can is the gas that was found on her body, which they're not going to be able to do, it's just another piece of a very large pie. And I don't know how important this particular testimony is going to be to the jury in making its decision.
Well, the lack of forensic evidence has certainly been an issue. Jonna Spilbor, thank you so much for coming on. Can't wait to have you back. We have to take a quick break. We'll be right back.